the entry barriers, and zero price is considered a pre-entry pricing, and same price is considered cartelization. While the computational regime considers negative price as something promoting competition. So in competition law, you can have all these possibilities: high price, low price, zero price, and the same price is bad, but negative price is good. So that is the exact logic, the same kind of sets of today we have when you deal with the general regulators and special regulators or sectoral regulators. It's because sometimes we think that the competition law is a general law. Actually, to me, it is a special law. It all depends on the circumstances you are talking about. It deals with one special aspect of the market, and hence we say also generally believe that a special law prevails over general law, and that is the precise provision in the competition law that notwithstanding anything contained anywhere else, competition law prevails over all other laws. But the more important is not the issue between the competition general regulator and special regulator or sectoral regulator. We have exactly same issues among the sectoral regulators. We have the issues, people going to courts. It's not the parties going, it is the regulators who going, Foreign Markets Commission and Central Regulatory Commission, to decide that under whose jurisdiction the futures markets for electricity comes. There are people who have gone like, say, who will regulate ULIP? There's a fight between the SEBI and IRT, and that requires an ordinance. So it's not the issue is between the general regulator and special regulator. Actually, it is the issue among the people who are managing these regulatory bodies. Most of the problems arise how you look at things and who want to essentially trying to protect one's stocks. Quite often, maybe advocates, maybe clients or the parties, they try to take advantage. To me, to my understanding, the market for futures for electricity was the fight among the people who were preferring a particular forum. It was a proxy war among the regulators, but there are people behind them who are fighting that, okay, this should be regulated by this regulator because there is some regulatory arbitrage. I am also aware that quite often fight also goes to advocates. The fight among the competition law and patent law. It is, to my knowledge, it is a fight between the lawyers of competition who are specialized in competition law, lawyers who are specialized in patent law. This is actually trying to protect their rights. In my area, I am making my livelihood. How can they come and take this away? So this has to be in my area. So it is actually the people, the clients, the parties, the regulators and the advocates all try to take some kind of regulatory advantage, regulatory arbitrage, and then they come up with these kind of excuses. This is nothing to do with problem, is not with the competition general or sectoral, notwithstanding that I am not completely ignoring the problem. But 2 points I would like to mention before other panelists talk is that competition law, the way it is today and the way it is evolving over 5 years, 7 years, I don't see. Competition law is very limited application, section 3, 4, 5, and 6. It's not, the competition law deals with only certain illegal competitive matters, not all anti-competitive matters. But most of the competition concerns arise or will arise in the next 5 years, 7 years from the misdemeanors happening outside India. It is merger anomalies happening outside, cartel happening outside, abuse of dominance happening outside. Probably very few things would emerge from India. If that is the case, all other sectoral regulators, though they have some jurisdiction over matters, somebody doing something outside affects the legitimate or interest of India, somebody manipulating the securities market in India, SEBI can still take action, even if the manipulation is happening from outside, but that's much more limited. So practically, for all practical purposes, the jurisdiction of all sectoral regulators is limited to India, while the jurisdiction of the competition commission is mostly outside India. So that's why, again, I am not wishing out the problem. There are problems in the language, Electricity Act rights that notwithstanding anything from elsewhere, competition matters will be looked after by electricity regulator, competition regulator rights, and I am not wishing out those problems. But essentially I am saying is that there is actually these jurisdictions to a large extent are different, and it matters a little how they are operating. And as you know, there is very little consultation among the regulators. because as I first told that the limited area is 3, 4, 5 and 6. But most of the anti-competitive things are in the policies, rules and regulations of the government of India, regulators, state governments, all kinds of people, including Register of Cooperative Society, as a matter before compact where Commission told that no, it's not my jurisdiction, but Commission told us it is within your jurisdiction because it is restricting supply, fixing price, all those kinds of things. So most of the things which are inherent in the policy and regulations could be anti-competitive but not illegal. This is the bigger area where which the area of interface between the sectoral regulators and the competition regulators. For example, SEBI decides that the price payable for the services of mutual fund agents cannot exceed this or cannot be below this. This is a policy matter. They have done in some context to pursue some public objective. You can consider this to be anti-competitive because it is restricting the freedom of people, but it's very difficult to consider to be illegal. We had an issue where another professional regulator, Chartered Accountant Institute, told that I am the regulator of the profession of the Chartered Accountants, and also I am the developer of the profession of Chartered Accountants. I want my people to have continuing professional education. They must have X number of hours of continuing professional education every year, but they must take that education from me only. So I am the sole provider of that. And Competition Commission prima facie felt that this is anti-competitive and that is before the court now to know what would happen. The point I am making is that quite often the regulators are engaged with certain public objectives, protection of investors, those kind of things in consumer interests which are not necessarily illegal, and most of these regulators, particularly infra regulators, all of them have a major role in development. They have a much smaller role in the regulation actually. If you look at the preamble of the SEBI Act, it said that SEBI is for protecting the interests of investors, developing the market and regulating the market. So in fact, SEBI's role or any of these regulators' role is much less, not much less. They have a major role in development where there is no clash between the sectoral regulators and general regulators. So to me, because of the developmental role, because of the jurisdiction outside and inside, I don't see much issues except that it is all depends on the personalities. We get into some problems, but if they try to live in harmony, I don't see any problem. Thank you.